We thank you so much for watching Law School Made Easy at Law School Made Easy 256. We want to go to the principles of criminal law. If you are in first year, first semester, this video is made for you. We are going to summarize the topics you do in first semester, but I am picking out the principles that you must pay attention to. You hear people saying grasp the principles, the principles, the principles. So we want to break them down for you such that you can appreciate these principles under criminal law. Criminal law 1 tends to be a bit stubborn, a bit hard if you don't read cases. So ensure that on every number, you're doing 4 numbers. Ensure on every number you have 10 cases. Yeah, to some of you who don't want to read cases, now you have said, oh, what? Yes, 10 cases per number, you are good to go. So let's enter into the principles. The first thing, now I want to go into definitions of actus reus, mens rea. We are only picking out the principles because now I'm talking to a first year student who has been at the law school. The presumption is you now know actus reus, mens rea, vicarious, strict liability, principle of legality. You know all these things. I'm just going to touch on those areas they expect you to write about. Okay, let's now deep dive into the principles. The first thing they tell you at law school that under criminal law, that criminal law is a branch of criminal law where where Uganda, okay, comes to bring sanity in society. If you commit a crime which is criminal, you have committed that crime against Uganda. That is why in all cases we have Uganda versus the accused. It is Uganda complaining. Uganda is the one complaining. Uganda is the one that wants to put sanity in society. So you go against Uganda. So the rule is Uganda versus the accused person. So all cases you find Uganda versus Warusimbi, Uganda versus Victoria, Uganda versus Mugenyi, Uganda versus Nkonge, Uganda versus so on. So all those areas, okay? Now, let's now head to the first principle. They tell you that a person cannot be charged because of mere wishes or hatred. The principle is where actus reus and mens rea meet, you have commissioned a crime. You remember your lecture has told you where actus reus and mens rea meet, the crime has occurred. Okay, so that is the first principle. That is the general rule. That for us to be able to say that there was a crime, we must prove the actus reus and mens rea. Where they collide, a crime has been committed. Okay, so under such a question, they want you to discuss the elements of actus reus. You also discuss the elements of mens rea. Then you give other principles like strict liability, principle of legality, and vicarious liability as the other side. Now let's go to the other area, is the theories of law. These are the reasons why we study criminal law. So under this, they expect you to discuss the reasons why we study criminal law. These are the theories for deterrence, retribution, exemplary, rehabilitation, all those. But we expect you to put a case on every theory, and you explain. It is a common question in first year, first semester. Then we move to the other, not as a principle, but as a concept you must appreciate is the sources of law. Now, the sources of criminal law are the same as sources of foundations, sources of contract, sources of constitutional history, if they ever ask them. But the sources are in order. Let's take a pause here. You begin with the first source is the Constitution. The second is Act of Parliament. The third is common law, and then equity, then case law and customary. Then, of course, a question requiring you to do sources. Those are the primary sources. Then there are secondary sources, textbooks, magazines, journal. Those ones we talk about in secondary sources. But the primary sources are in order. You begin with the Constitution, the highest, and then you go to Acts of Parliament, common law and equity, case law, and customary. And even when you're answering a problem question, if you have a provision of the Constitution, you begin with that. If you have a penal code, Act of Parliament, you bring it next, and then case law. If you have common law principles, you put and then case law. Okay? So, that is sources of law. Then we cross to burden of proof. When you have a question about burden of proof, we expect you to discuss the meaning of burden of proof. You bring the golden thread principle under Wilmington versus DPP. After you have explained that Wilmington versus DPP set a principle, you now cross, okay, to the cases in Uganda where the principle which was established in Wilmington was applied. You give different cases. If your question is about burden of proof, remember Wilmington only defined that the burden lies on prosecution to prove. Now, the standard was gotten from the case of pension, means of pension. Okay? So there you say, this case established a principle which says that the standard should be beyond reasonable doubt. Then after you discuss the presumption, okay, under burden of proof, you are done there. Of course, there are cases. Then we go to principle of legality. It has the Latin name sine noe polena sine lege. I can't remember that in Marxism, but I know you remember. Now, that one is saying that nobody can be punished where there are no punishments prescribed, or if the crime is not prescribed. And the principle of legality takes 4 stages. Pre-existence, the law must have existed, the crime must have existed. 2, must be either to interpretation clause. Then 3, the law does not operate in a retrospective manner. It does not go backward. You give cases, discuss them. Then the other one must be clear. The law must be clear, reasonable, easy to understand. There are 4. So you discuss them each with the case and the provisions of the Constitution. Article 28.7, 27.12, 28.12, 28.7, 28.8, 28.9, all those articles. You give them the sections. Now, from there we go to strict liability. We have strict liability. This is an exemption to the general rule. Remember, the general rule under strict liability is under law is that where there is a crime, you must prove actus reus and mens rea. Now, under strict liability, we only prove the actus reus. You don't need any mens rea. The act, you are done. There's that famous case of MPC Fagan versus MPC Metropolitan Police Constable. Then there you discuss other strict liability laws like the Firearm Act, the Medical Act, and those very acts, Environmental Act, all those acts. You discuss those acts where strict liability, where there are strict liability. We find you with a gun. We don't know the mens rea, but if you use it badly, we charge you for the act. We don't mind about this. Medical, doctors, and the like. Then we cross to what we call vicarious liability. This is also an exception to the general rule. That, remember, we say that somebody to be charged, we must prove the actus reus and menswear of that somebody. But under vicarious liability, you are committing a crime. You are committing a crime. Someone commits a crime, and you who was not there, you are charged. Look at that case of Tesco supermarket. But under here, they want you to discuss the corporate liability, how a company is liable. How do you establish the menswear of the company? And this is easy. Read that case of Tesco supermarket versus Natras. In that case, a company, a supermarket, has directors. They organize the promotion, and the promotion to start from 1st to 30th, for example. So it ended on 30th. They told the manager at the supermarket, remove the posters. The promotion has ended. The manager did not remove the posters. So someone came to buy Natras. When he wanted a discount. They said, you know, the promotion is over. He said, but the posters are there. So he went to court. Reaching court, court held that the directors were not liable because they had communicated to the manager that please remove that poster. So the manager was liable. The directors were not vicariously responsible. The manager acted on his own frolic. So now there, the question is, how do you determine menswear? We determine basing on the agenda, the aim, the objectives of the company. If what you have done is in line with the objective of the company, then the company has menswear directors. But if it is not in the objectives of the company, then the company is not liable. So you explain in those areas. Then from there we cross to inchoate crimes, which we call incomplete offenses. There are three in nature: incitement, attempt, and conspiracy. Now under here, we want you to show how does incitement lead to a crime, like an incomplete offense. That you must show that the incitement reached the mind of the incitee. The inciter incited, and the incitement reached the mind of the incitee. I normally give an example. Look at my video about inchoate crimes. I give examples. If I tell you the government of 7 is bad, we need to burn it down. Then tomorrow we find you with a petrol jerrycan around the State House, then it means the incitement reached your mind and you want to commit. So we don't allow you to commit, but the necessary steps were taken. You begin to prepare, okay? Then attempt, you must prove that somebody put their mind together, and they together, and they started to prepare through an overt act, manifestation through an overt act, that is attempt. Then you go to conspiracy. There's a case in the Ara versus White. Then you go to conspiracy. You must show there must be an argument. 2 or more people coming together, there must be an argument. Then with the other one is under conspiracy, you discuss how somebody joins during, after, and before, during, and after. That's when somebody can join a conspiracy. Then you talk about the access of the fact for a woman, for a wife, under conspiracy. Then from there we cross to what we call parties to crime participation. That when a crime is committed, everybody have a degree of liability. Okay, so you talk about the principal offender. The issue is understand who is the principal offender. This is somebody who commits the crime, or somebody who masterminds the crime. Then who is the procurer, who is the counselor. The procurer and the counselor, they don't reach the scene of crime, but they encourage this crime to start. The procurer goes ahead to even procure, buy things for the people. The counselor gives advice. Then you go to aid and abetter. These two, they reach at the scene of crime. They encourage the crime to continue. The aider helps on the principal offender. Then the abetter is looking. No one should find them. Is keeping protection. No one should find them. Appreciate these principles. Then you cross to accessory after the fact. For a wife can never be liable under section 366 for protecting or keeping his husband away from liability. So she can never be liable. So from there you cross to joint offenders. Joint offenders under section 20, they provide that these are people who come together, one or more people, to commit a crime, but with a common intention and common purpose. Look at common intention and common purpose, especially there. Look at the case of Vicarious versus Uganda, where they said for us to prove that these people are joint offenders, we must prove that these people have a common intention and a common purpose. That is what is very important. And then finally, for this semester, inchoate crimes. These are the only offenses you have covered this semester. There are no any other offenses. Even if you see murder, you see theft, you see what in the question, it is not there. The only offenses you have covered are attempt, incitement, and conspiracy. Then, finally, defenses. Now, under defenses, there are many defenses: provocation, accident, mistake of fact, intoxication, diminished responsibility, insanity, many of them. A claim of right, ignorance of the law. All those are defenses. But for defenses, we look at its element. When does this defense stand? For example, if you're discussing mistake of fact, the issue is you have done something with a honest belief that what you're doing is right, but yet it is wrong. Look at that case of Sultan Majinga. R versus Sultan Majinga is a locus classicus for mistake of fact. So you look at the elements. For example, provocation. It can only occur if there is a dead body. Secondly, if the person you are handling is you under conjugal right, somebody so close to you, or somebody under your care. You understand? So you look at those elements. To what are the elements? For example, insanity. You must commit the crime. At the time of committing the crime, you cannot differentiate between good and bad. So if you cannot differentiate between good and bad, then you can raise the defense of insanity. But if you were, at the time of committing the offense, you would know this is good, bad, then you cannot plead the defense of insanity, intoxication, like that. So for defenses, look at when do they stand. Necessity. When do they stand? When do they fail? We are interested in when can one raise that defense. Is what you look out for. Necessity. You are preventing a greater harm from happening. So if you are preventing, for example, if there is fire in here, okay, and they don't allow to break these windows in my house, the windows, you can't break the glass windows and the doors in my house here. If you cannot break them, okay, but then there is fire, there is a child, so you break them to save the life of a child. When you break to save the life of a child, then you can raise the defense of necessity. You say, I was preventing a greater harm from happening, that's why I broke the windows to save the life of this child. There was fire in there. So look at that case of Stevenson, Dudley versus R versus Dudley and Stevenson, Lucas Classicus on necessity, and very many others. So this semester, those are the topics, and that is what they require you to answer. But all these videos, I have done each one of them alone, standalone, on this channel, Law School Made Easy. So look it out on this channel, then you can appreciate. But I've told you what they need, what you must know. Of course, the sections of penal code, you must have them on every point which has a section. Until next time, thank you so much. Cheers.